And I can remember the first meeting quite vividly. There were probably 150, 200 workers there. It was the organizers, I can't remember precisely how this occurred, but they wanted the workers to know that they had a lawyer. What they didn't know is that this lawyer didn't know a lot about agricultural labor law in the state of Washington. I had done some research before I went over there, and I found that there was a case decided by the Washington State Supreme Court. It was a case called Christad versus Lau, L-A-U, and it involved a small dry cleaning plant which did not have enough workers to qualify under the National Labor Relations Act. So although it was an industrial setting, and had there been enough employees, I think the break point was like 15 employees at that point under the National Labor Relations Act. But the state Supreme Court had decided, I believe in 1965 was the date that this case was decided, that workers in the state of Washington had a right to organize and collectively bargain free of employer harassment. So it was the National Labor Relations Act, which was passed in 1935, I believe, the Wagner Act, did provide for a federally protected right to organize, which was enforceable by orders from the National Labor Relations Board and ultimately courts. But agricultural workers had been excluded from the National Labor Relations Act, so they were in there wasn't any state in the country at that point where farm workers, I think, had a right to organize under any kind of state statute. But the state Supreme Court decided in this Christad versus Lau case that all workers in the state of Washington had a right to organize, and that it was protected by court injunctions under what was called the Little Norris-LaGuardia Act, which was a state statute. So in that meeting, I explained in Spanish to the workers that the state Supreme Court had provided that all workers were protected in their right to organize, and I tried to explain that they did have rights under Washington state law, and that we could, we could try to protect them. If people, for example, fired them because they were involved in labor organizing, that they would have some kind of protection. And just a few days later, after this, an incident occurred which was, in retrospect, a golden opportunity for us to actually go to court in Washington state and get an injunction against a particular grower. And what happened there was that in very near Grandview, Washington, there was a joint agreement by two particular growers, Don Riel, R-I-E-L, and Eli Patnode, P-A-T-N-O-D-E. And they, I believe that Patnode owned the kiln and the processing plant, but they both had considerable acreage, and they cooperated in the harvesting of their crops and then the processing of them at the facility owned by Patnode. And they got very, very upset when the workers went out, and there were a lot of harsh words yelled back and forth, and there was a picket line out in front of their houses and where the hop processing plant was. And Riel got out a shotgun, and he never discharged it, but he brandished it and intimidated a number of these workers by brandishing this weapon, making statements. There was a statement that was testified to later that he made in the presence of a number of workers that if this picket line didn't stop, there were going to be some dead beaners in the road. And I'd never heard the phrase beaners before, and the Gamboa and others explained to me that it was a derogatory term that was used about Mexican Americans. I'd never heard it before. Growing up in the East, I'd heard the term spics, greasers, used towards Puerto Ricans, but I'd never heard this phrase beaners, and I couldn't figure out what it was at first, and then the light went off. But so we filed a lawsuit with 7 individual workers as plaintiffs. It was called Garza versus Patnode, and that was filed in September of 1970, and it went to trial in January of 1971 in Prosser, Washington, in the Benton County Superior Court. The judge assigned to it was Richard Patrick, who was, I got to know him later. He was certainly politically conservative, but he was a judge who was going to follow the rule of law. And we had about a week-long trial. It was the first significant trial that I had conducted, and we won. And we got a very good set of findings of facts and conclusions of law. They're printed in a book called CCH Labor Cases. It's probably online now, but I can remember it was volume 65, CCH Labor Cases, and which CCH standing for Commerce Clearinghouse, which is a legal publishing outfit. But you could find that the findings of fact and the conclusions of law on that, where the judge holds, first of all, finds what the facts were in this intimidation, and holds that farm workers do have a right to organize under Washington state law. And that was our big breakthrough, I think, because there we demonstrated to the workers that we could go to court, we could win, we could have some protection for them, and the union used that in its organizing drive that was taking place that winter. So I would on occasion go out with some of the organizers to various labor camps. I would explain what the court did and how they did have a right. They couldn't be fired, for example, if they were involved because of their involvement in labor organizing. So that was the first step, was establishing this right to organize. And then, of course, there was the next step was, well, okay, they have the right to organize, but how do we get the organizers in touch with the workers in the labor camps? The growers took the position at that point that they could prohibit entry into the labor camps. And so one of the things that Gamboa and I had talked about was, well, it would be nice if we could bring a lawsuit at some point to establish that there is a right to access to those labor camps. And this had been litigated in other areas of the country with some degree of success. And on June 10th, 1971, I believe it was June 10th, I went to the Rogers Walla Walla labor camp, which was an asparagus operation outside the city of Walla Walla, with Gamboa, who had been there about 5 days previously and had contacted a number of workers who were very upset with the bonus system, again, that was in asparagus. And asparagus, of course, is a very backbreaking type of work where you're stooping over to cut the asparagus, and again, it has to be cut at a certain time, and the field becomes less productive as the season progresses. And so they were having, the bonus withheld until that season, and that was what they were interested in. So we went out there to get affidavits from people about filing a wage claim case against the grower for the use of this bonus system. And we had a copy of the contract that the workers had all signed, and we were contending that that contract had been violated as well. But shortly after we got there, this was on a Saturday, we drove into the labor camp, and there was an individual who was wearing a Walla Walla County Sheriff's uniform. And we later found out that he wasn't actually an employee of the Sheriff's Department. He had some kind of supernumerary status, but he was an employee of Rogers Walla Walla. But he, I believe he had a gun, and he had this uniform on. And so he demanded identification from us. There were actually 5 people there. There was Gamboa, me, a fellow named Erwin Nash, who was a professional photographer and photojournalist. He had actually published a number of pictures in a Seattle magazine and an article about farm workers in the Yakima Valley, I think in the previous year. And then there were 2 young women who were college students who were working as volunteers with the union that summer. I can't remember their names right now. But when we were told by the deputy, the fellow wearing the uniform, that he had checked with the grower and that we had to leave, and we said no, we're not leaving. I said, I'm a lawyer. I've got clients here. I gave them what was called my bar card, which was a plastic card that just said I was a member of the Washington State Bar Association, and I said I'm going to meet with people who want to be represented by me. And then a sheriff's car arrived with 2 other deputies. And I think this was when I first met Deputy G.O. Scotty Ray, who was, I think, was the second in command, I think, of the Walla Walla County Sheriff's Department at that point. And they told us we had no right to be there. I told them that we had a constitutional right to be there, and they gave us 5 minutes to leave, and we told Gamboa and I decided that he and I would stay, and if anybody was going to be arrested, it would be the 2 of us, and that Nash and the 2 women should leave in my car. So they did. We stayed, and we were arrested, removed from the labor camp, taken to the downtown Walla Walla Sheriff's Department, had our photographs taken, and then we were released. They did not handcuff us when they put us in the car, which was, I think, not a usual. So we were obviously treated differently than somebody who was going to be arrested for anything. I think it's standard procedure in almost all sheriff's departments that if you're going to arrest somebody, you handcuff them before you put them in the back of the car. And I did try to persuade these deputies, as well as the deputy prosecuting attorney, Jerry Votendahl, who came down to the sheriff's department and talked to us. And I said, this isn't just a simple trespass case, which is what we were charged with. This is something that is where there are serious constitutional rights involved. And I had, by that time, done a good bit of research on this subject, and one of the key Supreme Court cases was a case called Marsh versus Alabama. And this is U.S. Supreme Court cases. And that was a case decided in the mid-30s involving a company town in Alabama, a town that was actually owned by a particular corporation. And they tried to stop free speech activity in this particular town. And the Supreme Court said, no, you can't, by the exercise of property rights, you cannot deprive people of their constitutionally guaranteed rights. And that was the precedent that we wanted to use. And when we were charged with criminal trespass, we went to trial first in what was called the Walla Walla County District Court, which was a low-level trial court where misdemeanors, which is one of these, were tried, and we were convicted by a judge whose name was Howard Martin. Both Gamboa and I were convicted. They didn't buy our constitutional arguments very much. The lawyers, the ACLU was representing us at that point, and a lawyer named Jan Peterson, who was represented both of us at the district court stage. And at that point, in the Washington state legal system, you had a right to what was called a trial de novo, or a new trial, in Superior Court. And so we appealed to Superior Court, which was a court of record, which means that, you know, a transcript of the proceedings was kept. And we, at that point, became represented. I was represented by a lawyer named Charles Ellert, who's still here in the Seattle area. And at that point, this case had gotten a lot of attention nationally. And I got in touch with Mario Obledo, who was the director counsel of the Mexican American Legal Defense Fund in California, and I asked him if he would represent us as well. And so he came up and he appeared representing Gamboa, and was given permission to do that. And it was very important psychologically that we have a Mexican American lawyer involved. And there were basically no Mexican American lawyers in the state of Washington at that point. And so Ellert and Mario Obledo represented us over about I think 3 days in trial in Walla Walla County Superior Court. And of course we were again convicted by the judge, whose name was Al Bradford. And then the case went directly to the state Supreme Court, and the convictions were unanimously reversed, and the court held quite clearly that both labor organizers and lawyers had a right to go into labor camps over the objection of the property owner because of the nature of the rights that were involved, that they were First Amendment protected rights of being represented by an attorney, and free speech rights, where the organizers were going in to talk to the workers to try to persuade them to take collective action. So those two cases were very, very important, establishing first the right to organize, and second the right of access by organizers and others to go into labor camps to try to organize people.